Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. Yoink. All right, we have a question from YouTube user Hush Money, who says, I don't know whether my attorney dislikes me or my case or both. When we speak, they are fond of playing the devil's advocate and explaining various defenses to my complaint rather than concentrating on the evidence. I don't find this helpful as I am on an hourly retainer and I don't come away with value for what I will get charged for. I am concerned that this innate skepticism of my case will manifest into sloppy depositions. This person is not the right attorney for me. However, others wanted $35,000 up front in terms of a retainer, so the alternative was being pro se. Could you do a video on this dilemma? Yeah, absolutely. So, $35K up front sounds like you were dealing with a national firm as an upfront fee. That for either federal employee or federal litigation, I've seen that for both. So you went with an hourly route elsewhere. Realistically speaking, if you end up litigating this case hourly, it's going to be way more than $35,000. But that's neither here nor there. Attorneys play devil's advocate because they want to make sure, this is usually why people do it, it's certainly why we do it, want to make sure people understand both the strengths and the weaknesses of their case, because they have to have an accurate understanding of both the strengths and the weaknesses to make well-informed decisions. That's the simple answer. Now, on an hourly arrangement, I would say that most attorneys are actually less likely to play devil's advocate because they might want the case to keep going, right? Playing devil's advocate for a client might push that client to settle their case because they would have a greater realization of the risks inherent in their case. And that is often not what an attorney on an hourly basis wants to have happen, right? They want to make the case go longer so they can bill more, so they can make more money. That's not true of all firms, right? That's not something we do. It's not true of many talented firms who, fully live the ethos of putting the client's interest first. But it is something, that I would often see out of firms that I don't love, where they try to stretch hourly cases. And we have a video we just put up, I think this week, or I guess last week now, about that. Why is this attorney playing devil's advocate? I mean, it could be that sincerely they believe you do not have a good grasp of the risks inherent in your case, and they feel a need to edify you on those risks, which you may not agree with, and they could certainly be wrong. I'm not saying they're right. I'm saying that could be what's going on. The other thing that could be going on is they might want to take time to bill you. Right? Like if they want to talk about the good parts of your case, that takes a certain number of hours. If they want to talk about the bad parts of your case, the risks of your case, that takes time too. And if they engage in both of those activities, they might get to bill double what they would have otherwise. I can tell you, certainly if you're working with our firm, we have conversations about both the strengths and the weaknesses of your case. We will engage in playing devil's advocate, right? Like you can say, I'll try to think of an example. Got to think of an example that doesn't actually attach to anyone who we actually represent in the past whatever years. Because I don't want someone to come and say like, "Oh, you discussed my case." Let's say you have an accommodation. You have some kind of sleep issue, and so you have an accommodation for your sleep disability. You can come in half an hour late when you need to. Devil's advocate, right? That's a reasonable accommodation because you have a disability and that's what helps you. That's what your doctor says helps you. Devil's advocate argument is, well, why didn't you go to bed earlier? Right? Like, you have trouble sleeping. We understand that. We don't mind accommodating you, but what does this half hour do for you? Right? Like what? Like if you have insomnia and you're getting, I don't know, some nights 2-3 hours of sleep, and that's not enough. We agree that's not enough. Frankly, that's not, we don't love you coming to work on 2 or 3 hours of sleep. what is this half hour going to do for you? What is the it sounds like the accommodation is just maybe something you wanted because you like to be late sometimes. Because what does this do for us or you, this half hour? If you're saying you have bouts of insomnia where sometimes you only sleep 2 or 3 hours a night, like you come in, you're basically a zombie because you haven't slept. That's not great for us because we pay you money, whether you're working well or not. It also doesn't make sense for you if you're driving around on 2 or 3 hours sleep. Like, why is the accommodation not intermittent FMLA where you stay home on those days, right? Then we wouldn't have to pay you to not work because FMLA is not compensated. But also, you shouldn't be driving on 2 or 3 hours of sleep. It's very dangerous to drive sleep deprived. So, like, devil's advocate, why is your accommodation stupid? What's wrong with your doctor? This isn't reasonable. You just like being late. Is that argument going to win? Not necessarily, but I'll tell you what. It's important to present it to your client. If your client comes in with that case where it's like, I have a disability, I need to come in half an hour late because sometimes I don't get any sleep. Okay. That could be legitimate. But presented the way I just described it, a lot of jurors might think you're just a piece of shit who doesn't like to come in on time. Because what does this have to do with you not sleeping? What does half an hour late have to do with you getting massive bouts of insomnia and getting 2 hours of sleep all night? What are these two things related? I don't know. They really are. It's going to take some work to present that they are related. That's going to take a little bit of narrative building. You need to make a story out of that. That story better be damn good too. Otherwise, people are going to be like, that story sounds like bullshit. And it kind of does, right? Like, and people come in with those cases. And it's important for attorneys to engage. And hush money, I'm sure this is not you, right? Like, I don't know what's going on with your attorney. I suspect you're a very knowledgeable person who's done the work to properly, like, look into your claims. You're engaged in this channel. I suspect you're a researcher. You're knowledgeable. You're all these things, right? So this probably doesn't apply to you. But I think a lot of attorneys will do the work of playing devil's advocate because a lot of clients don't understand the risks of their case, right? We recently had a video on the channel where someone was like, why would any plaintiff ever settle? Because cases have risk in them. That's why. Like, what? You know what I mean? Like, that's the reality. It's really easy to fall in love with your case. Like, it is self-evident that I deserve $30 million. Look what was done to me. And meanwhile, the jury's like, this plaintiff seems like a jerk. Like, why is this plaintiff coming in half an hour late if they have insomnia? I don't even understand the connection, right? But that hypothetical plaintiff we're talking about there is like, yeah, all I needed was half an hour. All I needed was half an hour. What are you talking about? I can't get my reasonable accommodation. It's so reasonable, half an hour. But that's not what the juror's thinking about. The juror's like, I'd like to come half an hour late, but I don't get to do that. What are you talking about? What does the half hour do? Like, how is that an accommodation? This person just likes to be late, right? And you gotta talk about that, and you gotta deal with that because that's a real hurdle to a given case, right? That might be hush money what your attorney's trying to engage in. Listen, it's also possible your attorney's trying to bill you. It's also possible your attorney likes the sound of her or his own voice. Not uncommon, right? So you are paying on an hourly basis. You can just tell this attorney, listen, I appreciate your thoughts. I appreciate the devil's advocacy, but that's not currently what I'd like to purchase in terms of your time. I'd like you to move this case forward, right? You can do that. You have the right to do that. You're the boss. You pay the bill. That attorney will have to, hit the metrics of their ethical duty. They're going to have to say the things to you that they feel they need to say. But once the things are said, once their ethical duty is hit, they can go ahead and just do what you like, right? Like that. Yep, I hear you. Thank you for your concerns. Thank you for setting out the obstacles and the risks in my case. I have a list of them now. Let's move forward, right? Enough with the chatty. Let's get to bat, right? Let's make this happen. Let's get this case moving. I've heard the risks. I've made my well-informed decision to proceed. The end, right? That's something they need to comply with, right? Or you'll find a different attorney. Like, listen, there is no shortage of attorneys who will take your money on an hourly basis. So, that attorney better shape up and fly right, or you'll replace them very quickly, right? And don't be afraid to push back on the bill. Like, hey, listen, you billed me for like $4,000 of you playing devil's advocate, and that was a lot of repetition. Like, I heard it the first time, so like, you can bill me $1,000 for that. Give me a no charge on the other hours, and you can go ahead and bill those additional $3,000 that you're no charging me on to move the case along, like we discussed. Right? That's a conversation you can have. They might not agree, but it's a conversation you can have, and you're the boss, and they should be working for you and doing what you want. So I don't think it's entirely unreasonable to have that conversation, right? It's common. It's common for people to come to their attorneys on an hourly basis and say, hey, love what you're doing. Everything's going so great. Case moving great. Good negotiations. Case so aggressive. I like it. I did see you worked on a mediation proposal over here for, 4 hours. And that cost me a couple grand. And I never said I want to go to mediation. So, why'd you do that? I don't think I should be charged for that. And the attorneys are going to have legitimate, like, well, we thought we were going to go to mediation. That's generally what happens in these cases. So we put together the mediation proposal to be prepared, and then it just didn't, mediation fell apart. Great. That's fair. But did you ask me if I wanted you to propose a mediation proposal or put together a mediation proposal? You didn't. So let's go ahead and no charge that. But this is all fair play, right? You can have these conversations. Part of hiring attorneys is managing attorneys. And attorneys are going to do what they think is best, hopefully. And at best, they're going to do what they think is best. And at worst, they're going to do what they think puts the most money in their pocket. In either scenario, you will occasionally have to rein the attorneys in. We're like, I appreciate that you're doing what's best for me in your eyes. But that is not what I told you to do. So I will not be paying for that. Fair. Now, there's other things where there's no choice. Like, you can be like, hey, don't do discovery on my case. And the attorney can be like, I don't have a choice. That's malpractice. I can't commit malpractice. Like, you can fire me, but if you're going to keep me on this case, I have to do discovery. I'm not handing you a claim against my malpractice insurance or an ethical complaint against me. Like, I'm not going to yeet my license out the window because you are feeling cheap today, right? That's different. That's different because that's required, right? The mediation proposal is not required, especially if you're not going to mediation, right? Like, these are two different things. So context matters too, right? There's certain things that the attorney is ethically going to have to do, like read the file, right? Like, clients will call you up and be like, hey, I want a third opinion on my case and I want to pay you for it, right? Potential client calling you up. And you'll say, okay, but I mean, that's going to be very expensive because I'm going to have to review the entire file, the whole litigation docket. Like, this is going to take hours. And for me, my hourly rate's like $11.60 an hour. And they're going to be like, oh, I just want the opinion. I'll pay for the opinion, but I don't want you to review anything. Well, one, that opinion wouldn't be worth a rat's tuchus. And two, well, that would, ethically be highly questionable. I'm issuing an opinion on a claim I don't know anything about. Like, pretty routinely when people ask me to second guess their attorneys, I say, well, it's going to be kind of tough because I don't know the case like your attorney knows the case, right? Like, your attorney was paid or compensated in some way or has some arrangement to make it worth her or his time to be well-versed in the facts of your case. They work on it to the tune of tens, if not hundreds of hours. And you're asking me to spend 20 minutes giving it a scan and issue you an opinion. Nah, that doesn't make sense, right? If you want to ask me, if you want to give me a hypothetical, like a specific thing, like, hey, this happened just like I'm telling you it happened, and based just on what I'm telling you, what do you think of that? Maybe. If I feel I can, in good conscience, then I will. But also, if I have the time, right? If you catch me on a day where I have my clients needing things, and you're like, hey, I'm not your client, but I want you to do this thing. No, I got clients. My clients come first, right? everything good in my life flows from my clients. Also, I have ethical duties to my clients. Also, good business. I must take care of my clients, right? Helping my clients is how I make money, right? So there is absolutely no chance, because I have personal interest, ethical interest, moral interest, and good business interest in helping my clients over you. So if you're catching me on a day when I'm busy and you're just like, do free work, bye, you know, which gets me negative reviews on the internet. That's not gonna move the needle, right? Like, it's not. This is a business, right? Some idiot got mad because he wouldn't do free work for him and left a negative review recently. Not gonna identify him because New York State would be like, you can't mock people when they leave you negative reviews, even if perhaps what they're leaving is mockable. Anyway, I digress. Hush money. I don't know fully what's going on with your attorney, but like, when you're paying hourly, you can often have your pick of the litter in terms of attorneys. So I would address the issue with the attorney, see if you can remediate the problem. If you can't, replacement should be very easy, and I suspect. If this was helpful, like, subscribe, comment down below, share the channel so it can grow. I hope that you are all well. I think this video is going live on Sunday, so I hope you're having a lovely weekend. Take care.